We're going to get started for the second part, special topics in copyright with Kenny Cruz. It was scheduled from 1 to 2:30, but we're going to finish at 2:15 just to get him back on the West Coast. Yeah. So thanks again for coming in, and all of you out there. And Kenny, anything else I need to say?
That's great. Thank you. Thanks to everybody for coming back. Thanks for everybody who is online. I appreciate it very much. And yeah, we're gonna move through two topics in this session, and how we balance them out to be determined. Depends how engaged we get in our conversations along the way. So again, like in the morning, questions, interruptions, slowing me down for whatever reason, all of that's fair play. So just shoot your hand in the air, I'll see you. Two big topics, a catch up on the principally where we are with the Georgia State case involving Georgia State University, because that has implications immediately for e-reserve, but also for addressing that question that came up this morning in a couple of different ways. What can I say, cut and paste and copy from somebody else's copyrighted work into the learning materials that I'm creating and make those available to students by whatever means? And that's that. While the case is not about that, like most of these fair use cases, they shed some light on the issues to help us understand and possibly reach a conclusion, some at least informed conclusion about where we are on that issue. So let's get started. This is a bit of a catch up on where we are with the case. So imagine, I'm going to digress briefly into a tutorial about the judicial system of the United States. We all hear about the Supreme Court. It's been in the news lately. But our basic structure of the court system in the United States is 3 levels. Case begins at the district court. There's an appeal possible to the Court of Appeals, and then a case can be appealed from there, petitioned to the U.S. Supreme Court. Now, very few cases by percentage get to the U.S. Supreme Court. They decide only 80 or 90 cases each year of the many, many thousands of cases going on in the lower court. So it's a tiny percentage. So most activities occurs at the district court level. Some cases go to the Court of Appeals. What's happened in this case is like every other copyright case. It begins at the district court, and they actually had a trial. So trial, collecting facts, testimony. I testified as the expert witness for the university during that trial. And in the year 2012, the district court handed down its decision. The publishers who brought the case were not satisfied with that ruling, and they appealed to the Court of Appeals. The Court of Appeals, sitting in Atlanta, modified the rules of fair use a little bit and then sent it back, the word is remanded it, back to the district court to re-examine the facts in light of our little changes, minor, relatively modest changes to fair use law. And the district court did. And it handed down the opinion that's briefly summarized here. By the time it got back to this court, there were only 48 instances of alleged infringement still at play in this case. And 4 were found to be infringing. 44 were found to be within fair use. So overall, this is still a very positive decision for the university. Now, the court at this stage, the district court, didn't say a whole lot about what fair use is. It's just basically doing its best to reiterate what the Court of Appeals has already said. But along the way, to make clear, some of this case, whatever it represents, does represent some major developments in fair use law. Because starting with those 1976 classroom guidelines, and if you've looked at anything about fair use in the classroom, you've probably come across these. They're the ones that would have you count the number of words and so on before making copies. Those, while neither of the courts handling this case have said straight up, we're throwing those out. They have made emphatically clear that they are totally inappropriate as a measure of fair use. The court, at the best you could say that they are now is evidence about what fair use might mean, but they were not at all a convincing measure of fair use. So I think we really should be, with our universities, if we're still using a policy based on that construct, we should be rethinking it. And similarly, one of the reasons the courts didn't like it is because they were highly quantified, measuring, counting words, percentages, that sort of thing. And the courts in both the district court and the Court of Appeals made emphatically clear that fair use is a flexible doctrine. It doesn't have these quantified measures in it. We need to judge based on overall circumstances. So we're moving firmly away in these decisions from a quantified measure. And then something else that's been kind of part of fair use thinking, for better or for worse, for decades, has been the one-time use rule. And the idea being, if I put it on reserve, if I'm teaching my class here at FAU, if I put that chapter on reserve this semester, is it still fair use? Let's assume it was fair use in semester 1. Is it still fair use in semester 2? And when I teach the course in semester 3? And a lot of models of fair use thinking have said it's a one-time use for fair use, a second time requires permission. The district court clearly did away with that and was not ready to adopt that. And then there was no mention of it by the Court of Appeals. So there was nothing there that they latched onto. So I think we can safely move away from that rule as well. All of this is reminding us again that fair use is deliberately a fluid, flexible doctrine, so we can change it and adapt it to meet changing needs.
Isn't the one-time use part of the classroom guidelines?
It is.
Okay, because it came from Con 2, from the first
from even before that, from all the way back to 1976.
Con 2 conference, the one that was yes.
Yeah, Con 2 was mostly about interlibrary loan copies, but there were those 76 guidelines. But yeah, they were buried in there as well. And so the courts have implicitly push that rule to the side. So I think we could be rethinking our policy making if we have that notion of one-time use in there as well. So we need to loosen up. We just need to loosen up a little bit about how we approach this. Now that doesn't mean a whole lot more is fair use. It just means that our thinking needs to be more flexible and really built around these 4 factors: the purpose of the use, the nature of the work, the amount that we're using, and the effect on the market. And you can see, got them summarized here. And by the way, I'm raising more questions than the cases answer. Because one thing to also keep in mind, the Georgia State case really is only literally about the use of scanning of certain book chapters and including them, sometimes not even a chapter, and including those pages into a closed, e-reserve kind of environment. So if your question is, well, what about the use of artistic images or poetry or other kinds of works or use in other circumstances? While the Georgia State case really didn't answer those questions, it at least gives us some guidance, kind of steers us a certain direction. So the nature of the work, nonfiction works tend to be more favored. But then again, the court also concluded, as you'll see another quotation coming up, that this factor in the end didn't make a big persuasive difference to them, to the judges. Because the notion of the nature of the work is kind of irrelevant in a classroom educational setting, because all different types of works can be suitable and appropriate for meeting our educational goals. So again, look at these issues flexibly. We've already said a lot of this about the amount, the classroom guidelines, rigid standard, repeat use, out. I'm going to move to this. Effect on the market. Now look at this quotation. That in determining, so now the question has come to you. Can I include these pages from this book, scanning them and uploading them onto our e-reserve system? Effect on the market is the fourth factor. And the Court of Appeals, in its review of the case, put a greater emphasis on this potential market harm. And here's some ways that it looked at it. It did look at possible licensing revenue. So if you could have gotten permission and even paid a fee to the publisher or other rights holder to include that content, that's relevant because that's establishing the market. And if we go ahead and use it without paying that fee, there is potential market harm. Now be careful. Like all of these four factors, there's no one of them that dictates the decision in the case. So even if one factor weighs against fair use, you got three more. They might go the other direction. But just on this one, licensing is relevant. But if no license is available, so you check the market, and there wasn't, the publisher was not giving permission for that use of the work. The inference is that the author or publisher did not think that there would be enough market demand to bother making the license available. So the question becomes really factual and pragmatic. Before putting this content up, how much of a market check do we need to do? And investigating whether or not a permission is feasible, easily available, affordable under the circumstances before making the decision to post something. In a full analysis, we might have to do that. But if you're running the e-reserve system and you've got 1,000 items that you need to review and evaluate, do you have time to effectively, efficiently do an individual search for each one? So there may be some basic searches you could do. And there's also, like in all decisions, a certain risk analysis. Where might we be willing to take some risks and maybe balance that out by some protections elsewhere? More about the effect on the market. Because the defendant, that's the universities, use is non-transformative. Now, if you think back, if you were here this morning, think of those, the Carey photographs that Richard Princeton transformed into some new artistic work. That is a classic transformative use. Pretty Woman Song turned into a new song by Two Live Crew. That is a classic transformative kind of example. But the court says because this use is straight copying, and the court says is non-transformative and fulfills as a reading the same educational purpose that the plaintiff's book publishers were trying to fulfill by supplying these books, at least in part. The market, they market their works for that. The threat of market substitution is great. And the fourth factor looms large in the overall four-factor analysis. So think about those four factors. Generally speaking, in our context, in the Georgia State context, nonprofit education, et cetera, tends to weigh in favor of fair use. The nature of the work, the court said, that's kind of neutral because any type of work could be suitable more or less for teaching. So that's kind of neutral. That sort of hovers in the middle. The amount, if we're using a modest amount that's strictly defined and appropriate for the educational needs, that tends to favor fair use. So we kind of have two in favor of fair use, one factor sort of caught in the middle, and then the fourth factor looms large. Now, what does that mean? It doesn't mean it weighs against fair use. It's just the court's way of saying we might end up giving this more weight if there is a market, an active, reasonable, reliable, easy market for that particular work. So it's emphasizing again, maybe we need to take a little brief look at the market and see how this is available. Is that your hand going up?
Yeah, kind of. I mean, the market, not only is it, this is something I didn't like about this ruling. It said the market is large, and yet it also looked at how many licenses were given out for the given product if the license was available. And
Right.
if there were very few that were given out in that given year, then it didn't have a big impact. But we can't do that kind of analysis.
You're exactly right. This is a dilemma. This is a dilemma. So what the court did that was strongly favorable to the universities in the context of the court case was it put some of the burden on the publishers that if you're going to raise this issue about licensing and market harm, you better be ready to present the evidence. So that's favorable to the university because the university doesn't have that evidence anyway. Come on, be reasonable. And so that was favorable. But then if you take the lessons from this, as we're doing right now, and say, what lessons can we draw from this language to help us draft a policy that will help us do the right thing about fair use? We're left to struggle with, well, we're going to make a fair use decision based on market harm when the only way we can get the information about real market harm is by asking the publisher or getting sued and sending them a subpoena. We don't recommend that. And so we're realistically not going to get all of that information. So true in life in general, you're going to make decisions based on incomplete information. That's okay. All of life is like that, right? You send a birthday present to somebody and you're not sure you got the right date. You just, life is full of risks, big and small. See your hand up.
So is it best in light of what you just said to ask for forgiveness rather than permission?
Or somewhere in between.
Spoken like a lawyer.
Hey, that's why we get paid. But somewhere in between, it's best to do the best you can with what you have. Let me take it even a step further. It might be on the next slide here. Go this slide. In the district court decision, the district court included in its fair use analysis a kind of a 10% rule. It was more complicated than that. It was up to 10% of the book if it has fewer than 10 chapters, only one chapter if it has more than 10 or something. Maybe I've even got it wrong. Did I get it right? Even if I got it wrong, that's okay because it's gone, the key word. Because on appeal, the Court of Appeals said that that is quantifying fair use in a way that we are rejecting and we think is wrong. The fair use doesn't have these quantified rules in it. 10% of one item may be too much. 10% of the next item may be just way less than fair use could justify. It just depends on what the work is and under the overall circumstances. So back to our policy making. When this rule came down, academics, universities, library folks, they responded two general ways. There was one group that said, oh, thank heavens. At least give me some operating rule of thumb so I could just make some efficient decisions and move on. Seems really reasonable. And 10% seemed generally reasonable to meet most needs. I heard a lot of people say, okay, sounds pretty good as a practical matter. And then there was another group of our professional colleagues that said, no, this is a terrible mistake to think in terms of 10% or one chapter, because we do need to be more fluid. But then pity the poor person whose job it is to write and implement a policy. So thinking back to your question, forgiveness, get it just right, somewhere in between. Maybe the somewhere in between is there's nothing in the law to stop you from making and adopting in your policy some kind of rule of thumb to guide you through this maze. You might very well still say, and we can look around the country, we'll find hundreds of examples doing this, and have been doing this a long time, have a 5% or a 10% or a 20% rule in your policy, along with many of the other concepts. But just as sort of a guidepost, 10%, for example. And there's nothing wrong with that under the law. But what you're doing is you're saying, for the sake of efficiency and implementation of a standard and fairness, which is what a standard also should drive us toward, I'm going to take a little risk, and I think this would be a modest risk, that I might be under measuring fair use in one instance, not allowing enough with my rule of thumb. And I might be over measuring it. You know, somebody might accuse me of something in the next instance. But maybe that's a risk I can absorb. Because after all, you know, it's a reasonably private decision. It's not one of those projects that we're parading out on the internet for all to see. And you're implementing it not just as a 10% rule, but you're doing everything else. And we'll talk about more of that, like a good fair use policy consistent with what we know, consistent with this case, will still say things like purpose is limited to teaching the courses. It's not for entertainment. It's not for amusement. It's for teaching the courses. The amount selected from each book will be carefully tailored and reduced down to just what's appropriate to meet the educational requirements and expectations of that course. Only students enrolled in that course will have password-restricted access. We will post a warning notice so that we tell them if you abuse it, we're going to lose it. This is for your purpose, only in connection with this class. Do not share with anybody else. We're going to do a lot of other things as part of writing and implementing our policy. And then to help make us more efficient decisions on amount, maybe you will want to say, I want something semi-quantified. Give me some guideposts. And the next university will say, absolutely, it must be quantified. And the next university will say, don't give me any quantity at all. We're going to judge it one at a time. Every place is going to be a little bit different and be able to absorb that task a little differently. How are we doing? How are we doing? As you think about 4 factors, and you think about fair use policy making and some of the other issues we might build in our policy, where do you see this taking you? I promised you could ask questions anytime, and now I'm asking you a question. You know? Where do you see it taking you to? A lot of the questions we had this morning were about clips and pieces for my online education. What about a clip of a movie? What does this tell you about how much you can use of a feature film in connection with teaching your course? Mm-hmm.
What is appropriate?
Yeah, what's appropriate? You know, because this case, while it had nothing to do with feature films, it was all about book pieces, pages, and chapters. It still is about fair use. It still tells us a little something about fair use. Do you feel more comfortable? Maybe I'll ask a more specific question. Do you feel more comfortable having seen where Georgia State case allowed the use of pieces of books to be able to say, I think I can figure out a fair use limit for pieces of movies as well?
Sure. One uses only that which is necessary to evoke the point or to make the point.
Okay. And if my point is I'm teaching something about a business course, and I want to use this scene where people are negotiating in a feature film. 5 minutes. Sound okay?
Sure.
Sound okay? What if I'm teaching film studies? And I want to really examine a particular film very closely. It's a 2-hour film. So instead of 5 minutes, I really want 30 minutes, 40 minutes to really get all the necessary pieces to make my point. What would make you feel better about fair use?
I hope I'm not mixing apples and oranges, but I would advise a transformative use of that film. In other words, break it into pieces to make the point
Aha.
of the education, and then give the example, and then the next point in the example.
Excellent. So in other words, if we're in a live room, maybe I go, now watch these few minutes.
Right.
And then I stop, and then we talk about it, right? Now let's watch a few more minutes. And we stop and we talk about it. Or like one of the questions we got online this morning in the online group, maybe that person's still listening out there. I'm now gathering all of these teaching things, and I'm putting them into putting them as one cohesive unit on a website where students can drop in on their schedule. Distance education, right? And so I show the couple of minutes, and then I splice in a slide with some questions and so on. Then we show a couple of minutes, and I splice in a slide with some questions. Start to sound better?
Yes.
Yeah. An effect on the market. How are we going to hammer down any possible effect on the market? We talked about this in another context this morning. Well, maybe we just buy the darn film, you know? Even though the one we duped some pieces out of came out of my personal collection, that's great, that's a start. But, you know, maybe we make sure that there are a few copies available on DVD in the library. DVD films are still not terribly expensive. You probably wouldn't break your budget to buy those. And have a few copies because after all, you know, this is a really important film for teaching my film studies class. I'm going to want you to go see the whole thing anyway and see what it's like from beginning to end. So it's educationally appropriate to have more copies, and you're helping the market.
Is there a difference between films made for commercial purposes versus educational films, media, even documentaries?
There's a big difference. Tell me, let me twist the question, just to play with the question a little bit. Let's think in terms of those 4 factors. I'm going to see, I think I can get there pretty quickly by backing up. Kind of starts, purpose of the use. Well, there, just those 4 words across the top. Purpose of the use, nature of the work, amount that you're using, and effect on the market. Which of one or more of those factors could be relevant if I'm using, say, educational film versus a critical study of Goodfellas, a feature release Scorsese film?
I'm thinking purpose there.
Okay. Well, purpose of the use, well, maybe. What's my purpose? Maybe you're onto something. How is my purpose different?
Oh, so you're saying the distinction between the two?
Yeah.
Okay.
What I'm trying to do, you asked the question, is there a difference? I'm just rephrasing the question just slightly to urge you to think about what.
Then it's the nature of, hold on.
It's the nature of the work that you're using.
Yes, the nature of the work is different.
Okay, it is different. Feature film, educational film.
But my purpose is both education.
Your purpose is education. How does you are 100% right that there's a difference in the nature of the work. How is that a difference that makes a difference? So in other words, how does that affect whether it tips the nature factor in favor of fair use or against fair use?
I would argue
Okay.
that using an educational video made for educational purposes actually is an advertisement in my class for people to go out and buy. Oh, that was a really great educational video. And this happens.
It happens.
Right.
And therefore, if this is my career, I might want to go have a copy of that film myself,
So
right?
I'm actually giving them free advertising
Okay.
as opposed to,
Anybody want to make a different argument? What argument is likely to come back against you?
Well, no, my argument is that the company that made the film made it for educational purposes. So my buying the film implies that I'm going to be using it for those purposes.
Okay, and if I'm also making clips and copies, maybe what I'm also doing is I'm interfering with exactly their prime market. Ooh, because in the photocopy cases that we had in the 90s, we did have some cases, sometimes the court would say, it's the fact that you're making, in fact, a little bit of this came up in Georgia State case as well. You're making copies of books that are marketed specifically for students at universities, as opposed to just general interest on the U.S. Civil War, put it on the shelf with the other Civil War books. Some of these were like textbooks, marketed especially for students. So if that's the nature of the work, we could argue that you were helping the market, or expect the counter argument, the other side, to say, no, you're interfering with our primary market. I see your hand up over here. Is there a hand from offside?
We do.
Great.
We have a couple questions, actually.
Just pick one.
If I publish a website with current revolving, with content, should I say, revolving around my artwork, i.e. creator-owned content, and specifically stated on it, there's a minimum fee for any professional use. Professional. Includes nonprofit, educational, governmental, non-governmental sectors, along with other
Hang on. I'm going to ask you to save that question. That's somebody building a business. I'm going to happily talk to them. Let's go to the next question. You got one about fair use? Sorry, folks.
No worries. In an online course, does it make a difference if we cite the source as well as using small pieces?
It's a great question. It's a great question. Go back to those 4 factors, and there's a more full, I know that some people here and there were not with us in the morning where we got into the 4 factors a little bit more thoroughly. But you'll find 4 factors of fair use. And the question about giving credit, if you look at those 4 factors, there's no requirement, it's not even a hint, that giving credit is part of the equation of fair use. Now, for a whole long host of reasons, starting with the plagiarism thing, give credit, give credit, give credit. Absolutely, positively do it. But it's not at all, not only is it not the be-all, end-all of fair use, it may not even be relevant. It may not even be relevant. And where it has come up, it's largely come up in terms of the purpose. If you're citing your source, that further affirms that your purpose is sincere, beneficial, part of the educational process. So for all kinds of reasons, do cite your source. I saw your hand up here.
Yeah, so when it comes to film, for example, if I buy a film and I'm showing it to students in class,
Correct.
that's fine.
That was that section 110.1 that you may or may not have been in the room, that we got to. There's a separate statute exactly on that. So if we're in the live classroom and I show the film, we're okay. Nobody made a copy. I put the DVD in the player. It showed up on the screen. No problem.
Now, I'm not connecting through my Netflix or Amazon account.
Not doing
So
any of
I'm
that.
buying the movie physically and putting it in the machine.
So far, so good. We got a statute to tell us that. Section 110.1. Follow up on that?
What's that?
Did you have a follow-up on that?
Well, I believe this is fine too. If I'm telling students, okay, you're responsible for watching one of these 3 movies, figure it out. If
You're
they
fine.
go look it up on YouTube, that's not my problem.
Not your
But
problem.
if they buy it,
Not your problem. You might use the opportunity to give them better suggestions for where to find it. Go to the library, go get your own Netflix account, whatever.
that's fine.
Yeah. But yeah, it's up to them. It's up to
But
them.
we definitely don't want to be saying it's available on
Yeah,
YouTube.
exactly.
I got this guy.
So back to this question though about film and educational film versus feature film. You know, if a copy of Goodfellas is readily available at $9.99 from different sources, but a typical educational film might be $100, might be $1,000, might be $6,000. I've seen all kinds of prices for educational films, and usually it's not a cheap price. These are usually high end. The argument's going to come back that when it comes to that effect on the market, This is a tiny market, certainly by comparison to a feature film. This is a tiny market. You at the university are exactly my primary market. If you don't buy it, who is? And therefore, even a small use could have a larger use by percentage, by impact on my market. That's going to be the argument that's going to come back. That's going to be the argument that comes back. So I'm not going to leave you without feeling a lot of hope, because probably what I would look for, what I'd want to find, is that you've used small pieces. Again, showing it in the classroom, no problem. We're just talking about copying pieces. That you would have very small pieces. You would balance out that argument against you by having very tight pieces, interspersing in a transformative way educational questions, provocative questions, etc., to make it a much more dynamic source than the original ever was. And that you would have fueled the market by making sure that some office, library or otherwise at the university has in fact bought a copy and made that copy in a collection where students then can see the whole thing. Those are the kind of things I'd be looking for. And notice what we're doing. We're taking a situation, we're adjusting, tweaking, revising, adding, moving, reducing amounts. We're doing different things. We're playing with pieces to get ourselves to the point where thinking within the framework of those four factors, we're getting to a comfort zone. You used this morning the other analogy of, this is giving me a headache. I want you to instead find a comfort zone. Where do you feel okay that now I can make this decision and I think I'm okay? Is there always a chance you're wrong? Of course. Is there always somebody to tell you you're wrong? Absolutely. There are people hired every day to tell you you're wrong. That's what they do. But your job is to get yourself to the point where you're comfortable and confident moving forward. And if we have a fluid policy, among the risks are that the person who thinks you're wrong, you either didn't do enough or too much, whatever, is down the hall from you. That person's operating under the same general fair use policy, but concludes, oh, I can't do that. You conclude, yeah, I can do that. And my reaction is, that's okay. As long as each of you feels that you're doing based on reason, good faith, interpretation, application of the four factors, you believe that you're really doing the right thing. Not all of us, I hate to use the car driving analogy too much, but just watch the way people walk across the street. Some people take more risks than others. Others are more comfortable than others. We just all go through life in slightly different rules, and that's okay. Is that hand up over here?
Yeah, we're gonna ask the last question a little differently. It wasn't business oriented.
Okay.
It comes from an instructional designer.
Great, glad to hear it.
And so what this person wants to know is he wants to use content from a site that states there's a minimum fee for any professional use, okay? Can this person still use one of his cartoons within a lesson unit where the cartoon would sum up textual content?
I'm not quite sure what the last little phrase means, but that's okay. Let me do my best. I think what the question is coming down to is, suppose, well, thank you. Just trying to chase me out. I think that what the question may come down to is, suppose we were to decide, okay, it's fair use to use this cartoon that somebody else owns the copyright to in a certain way in some classroom materials. Let's just assume we're all comfortable calling that fair use. Is it still allowed when I acquired that cartoon and that copy of the cartoon from some database source where I had to log in, where it came with a commitment that I couldn't use it for commercial purposes? And I'm going to assume it didn't say then anything about nonprofit, non-commercial uses like education, like what we do at FAU. And in that case, I think you're fine. I think you're fine, as long as it's still within fair use. And maybe, but read the fine print carefully to see if there's any prohibition. Read the fine print carefully to see if there's any good news, because sometimes that fine print actually has good news, and it says, and you may use this for educational purposes. Just give us credit, and then give credit. Follow the rules, and so on. So I based on how I understand the question, then I think we're heading in the right direction. I hope that helps.
Thank you.
Yeah, we're getting down to like 15 minutes. I've got one more topic. I want to talk with you about publication agreements. But any more questions about where we are with fair use, where we are with Georgia State, anything else?
I've got one question.
Sure.
What if you find something you want to use?
Oh no, we're going to go to
Ask the-
2:15, aren't we? Oh, we're in good shape.
You've asked the copyright holder if you can use it, and they say no. And then you go back and look at it and decide maybe it's fair use after all, and go ahead and use it anyway.
It might be. Isn't that a great question? Because in fact, we have court cases that go exactly like that. The Pretty Woman, Two Life Crew case went exactly like that. They went to the Acuff Rose, the rights holder of the composition, said, we want to make this variation on your song. And the Acuff Rose said, no, we don't want that awful thing out there. That was the way they looked at it. And so turned them down. Well, Two Life Crew being Two Life Crew, the Miami hip hop scene, they just went ahead and did it anyway. And said, okay, let's see what the lawyers say. And then the lawyers said a lot. But they ultimately prevailed. So being denied permission does not decide your case. But I would hasten to say that if you're denied permission and you use it anyway, and let's say we all agree it's fair use, but you're using it anyway, expect pushback. So you kind of have to decide, how much of a battle am I ready to take on? And if it's part of an institutional project here at the university, I'd check in with somebody higher up, make sure they know what you're doing. Yeah. And the reason why it's very important to appreciate that there's a really critical reason why that denial of permission does not decide your case. Because if it did, and this is what worries the courts, you would be discouraged from asking permission. They want you to negotiate, talk to these people, go see if you can work it out by permission. They want to encourage that. And if the court sent the signal that denial of permission forecloses your opportunities, then that's going to be discouraging you from seeking that permission in the first place. So yeah. You are legally okay. Just proceed, document everything very, very well. Yeah, up and down. Question
Yeah,
over here.
easy one for you.
Okay.
They're asking if you could please explain what you meant by transformative use not essential. One more time, quick.
Not essential?
Yes.
Yeah, be happy to. I think that was buried in one of the slides. And so yeah, let's emphasize this. Really important. So there's 4 factors of fair use. The first one, what's the purpose of your use? And this has been part of the law for a long time. And starting in the late 80s, early 90s, there was a movement to rethink that first factor by adding to it a concept of transformative use. That it isn't just purpose, as we've been thinking about before, commercial, nonprofit kind of distinction. But in addition to that, think about transformative use. So when you think back to some of those examples, well, let's stick with the Pretty Woman. That is taking the Roy Orbison song and transforming it not just into a new song with new lyrics and some new melody and so on, but also transforming it conceptually from the way, this was an important part of the fair use argument, that if you listen to the original Pretty Woman song and think of it like literary analysis, ask yourself the question, what is the story being told? What is the value structure that's part of that story? What is this song evidence about that concept of life that's going on? I don't know if you ever, so when Roy Orbison growls next time you hear that song, think about it as literature, because that's really what it is. And that was critical for this case, because the second song that is a transformative use took that Roy Orbison song and told a different story and said, we're going to evidence a different male-female relationship. We're going to evidence what it's like in our part of the town, in our years, in the 1990s instead of in the 1960s. We're going to tell you a very different vision about the way people relate to one another through the use of this song. And it's that critical commentary that was so important. That's what parody is. It's commentary on the original work. And so the court liked that for fair use and said, this is a transformative use. You're making something new and putting it to new kind of use. But as powerful as transformative is, it's not required. The publishers in the Georgia State case were arguing that the only way the court can rule that this is fair use is if it concludes that this is a transformative use, arguing that it's required. And that's just absolutely not supportable by any case law anywhere. And the court, in fact, in the Georgia State case made that point. This is not a transformative use, the court concluded. I think it is slightly, but it's not a transformative use, but that's okay. It can still be fair use. So they'll go back to the example about clipping the video and turning it into a teaching tool. That's a transformative kind of use. And so that's going to help weigh in favor of fair use. But just straight showing the movie, that could be fair use. We just have to look at the overall circumstances. So transformative is not required, but it sure is helpful if it's there. Hope that helped. Questions? Anything about fair use?
I don't know if that's about fair use.
That's okay.
Are there any special rules regarding documentaries?
Is to use them or to use
To
them
use
in them?
clips in a documentary?
Yeah, there are. In fact, there's been a very attractive project. It wouldn't take you long to do a web search and find it. Something called Best Practices for Documentary Filmmakers. And there's a series of best practices out there. This one has probably had the greatest effect because the documentary filmmakers were having just a monstrously difficult time getting their insurance companies. Most professional filmmakers and big film studios and so on will have insurance against whatever goes wrong with this movie, including any copyright infringements that might occur in it. And so they'll have the insurance companies were not recognizing fair use. And fair use is critical for documentaries. You're going to use that little clip from Fox TV. You're going to use that little piece of music that's important. You're going to have live action that occurs on the street. You're going to capture some sound in the background and a billboard that's up above the building. All this copyrighted stuff is in the film, and you need to have it, or it's not a good documentary. And so that the best practices movement really had some good success in coming up with some definitions and helpful guidance about fair use in that context, and getting the insurance companies to accept that as part of their protection for the filmmaker. And then what I thought the other part of the question might be, how about using documentary films then in our teaching? And I think we've answered that already in different ways. Yeah. Yes, please.
So do you think that if permission was given to use a piece of music for a public performance, and the public performance included choreographed interpretive dance, and it was performers gave permission, choreographer gave permission, and the music was given permission to use in the dance, and it was filmed, that qualify as a
And the
transformative
permission
work?
to film it was all there?
Not from the musicians.
There's one other piece that's missing. There's one other piece that's missing in your description. Did the owner of the rights in the music, did they also give permission for the choreography? Because choreography is a derivative work of music.
I'm assuming yes.
Yeah, here's what we would look for. Whether it's fair use or not, we've got a whole lot of other facts we need to know to begin thinking about whether this is fair use. But if you're talking about putting on this production that you described, capturing it on film, and let me guess, you want to share that film out. You want people to actually see the film, right? And so you're going to put it on a server. You might even put it up on YouTube if you could. If somebody says, okay, you'd like to do that, you're probably going to get a takedown notice right away because it's just going to trigger the bots that pick up the music and boom, you'll get your notice pretty quickly. Is going to be my guess. But if you're going to do it like a film producer, so if you're teaching a film production course or an art management course or something, you want to fold in a little bit of copyright management, business thinking into this. And you need to have, if I'm Cecil B. DeMille, film producer, and I'm making that movie that you described, I'm going to need permission from the composer, and I'm permission to include it in the film, and permission to make a derivative choreography. And then I'm going to need permission from all the performers. Are you using an existing recording of the film, or are you going to make your own performance of it?
We've already done it. Yeah.
Leave that part out of the story.
Years and years and years. Oh, we're recording, sorry. So permission was given by the music
The composer.
composers and to do choreography to it.
Okay, good.
But the choreographer and the performers gave permission to film it
Okay, good. But
and
not the
make it
music.
publicly available.
But not the music.
I don't know.
And plus, what I was also trying to ask is, who performed the music?
It was recorded.
Yeah, pre-recorded.
Yeah, it was
So
the original.
Yeah, the original. So you really need to go back to at least the composer about the choreography, and then for including in the film that you maybe want to publicly put on the web, etc. Yeah, it's probably going to get taken down right away if you don't have your permissions in line. Yeah, tough case to make for fair use. Now, if you said we're only going to do it,
Transformative.
well, maybe, but it's not a strong transformative argument. But if you'd said to me something a little bit different, which was, and we're just doing this in the classroom, we're capturing on film so we can all watch it afterward and critically analyze it. It's just a classroom project. I'd say it sounds like good fair use to me.
Part of a classroom grade.
Yeah, sounds like good fair use to me, but it's that putting it up for other people to see that kind of spoils the story. That makes it a tougher case. Good.
And then
Yes.
again, if it's in an online classroom, obviously you're putting it up somewhere for them to access, but you're putting it in the closed environment of an LMS. And so, is
Yeah.
there a distinction there? That's
There-
kind of a big question.
There is a distinction there, and we do have that code section 110.2. It's okay if you weren't here this morning, I only mentioned it because it really hasn't worked very well. Well, we're finding that most people doing what you just described, an online course with pieces from other copyrighted elements, that most people in that case are relying on fair use. They're analyzing fair use, they're putting in what they're comfortable about fair use, or they're securing permission or whatever else. Question here, and then I'll come back.
So the Teach Act hasn't, not the Teach Act, the DMCA for breaking, protection of those DVDs in order to be able to capture those 5 minutes, that's not an issue to really think about so much.
I've been avoiding that all day. Yeah.
Because so you just think it's not worth going into.
Well, there's a little bit, but it's very technical. What we're describing here is the DMCA statute enacted in 1998 created a new law, a prohibition against circumvention of the technological protection measures. So cracking the code on the DVD to go in and make content copies of those clips. Maybe the clips are perfectly within fair use, but cracking the code is illegal. So you can't do what's fair use. It's a dilemma. Well, there are some regulatory exceptions that slowly evolve, and there is one now for the use of clips for within fair use for education, but we'd have to go into a lot of arcane detail. So if you're there, if that's you, you're cracking that code, be sure to check with the higher ups, get some guidance before you use Handbrake or anything else to crack that code. One last fair use question, then we'll get on to our next topic.
Sure. So with distribution of a musical film on DVD, just to reiterate,
A feature release film.
a feature release film, a musical film, whatever it is on DVD and use within the classroom, online classroom, would the person need permission from choreographers, composers, et cetera, to use that?
Highly unlikely. So if it's a feature release film, usually it's West Side Story. I want to show this in whatever context. Let's skip fair use, assume it's not fair use, and go straight to permission. All of those rights you can, as a practical matter, just assume are all bundled together with one copyright owner. You know, the big Hollywood producer has done his or her job correctly, has all those rights brought together. One company owns all of those rights, from performers, choreographies, screenplay writers, you name it, and you only need to go track down that one party to get whatever permission you might need. I think that answers the question.
When we say one party,
The producer, whatever production company owns the rights. So you don't, as the end user, need to go to that cast at the back of the film and get permission from the 100 or 1,000 people at the back of the film. You don't have to do that. All those rights are consolidated with the one party. You can safely assume.
the producer.
The producer.
There's also, isn't there a possibility of just getting a licensing the public display version of that film? So it's a little more expensive.
Just get a public performance license.
Public performance license.
Yeah, exactly. And in fact, you know, there are many routes to do that. And including, you know, often when you buy the film, and libraries buy films from these film supply companies that have a higher price to get the public performance rights with it. Be sure, though, to read the terms of those public performance licenses very carefully. Because usually what I find they anticipate is it's showing the movie in the auditorium on Friday night to entertain the students. That's the public performance. And they're not thinking of, if you're doing it in distance ed, you're transmitting it out on a network, or you're copying pieces to put on the server. It often doesn't cover any of that. Go ahead,
I want
Carol.
to follow up on the public performance rights. So that statute that you talked about earlier,
Yes.
that specifically permitted showing films in face-to-face settings.
Yes.
When was that promulgated?
When was it enacted by Congress? 1976.
Okay, that was
It's been there.
76. Okay, so all the time that I've been involved in libraries, we've been careful about buying films with public performance rights in a face-to-face setting. We didn't need it.
You don't need it.
Oh.
I'm glad you brought it up.
We didn't need it. All those times that we were told we did, and we did.
Yeah.
You are not alone. It's all over the country.
What a bogus charge. we've been
All
doing.
over the country. You know, we've been buying things that we didn't need to buy.
Yeah.
And because if your goal for the use of that film is just to show it in the classroom, you know, or let people check it out, take it home, watch it at home, just go order it from Amazon. You know, go to
But if
Target
we
and
wanted
buy it
to
off
then
the
show
shelf.
it for entertainment purposes, that public performance rights would give us the right to do that.
Correct.
Okay.
If you want to show it in the auditorium,
Right.
which you're not going to do from the DVD anyway, it's not going to look right on the big screen. And so you know, but if you just want to show it in the meeting rooms, for entertainment purposes, then you might need the public performance rights. So it usually covers, you know, those public performance rights you pay extra for often cover either that which you already have the right to do and you don't need to buy anyway, or rights that you didn't want to pay for. They don't cover our distance ed rights that we wanted in the first place. So you're left to go track down the producer get some permission. One last question, then I'm going to go
Well,
to
just not in
something
the
else.
statement, but a good solution that I find with classes where online where students have to watch a movie is to see what the library has available that could fit the bill.
Please do.
And it's just streaming.
Yes.
Please
But
do.
if I wanted to ask people in the library, hey, do you think you could get this movie? We'd like to use it every semester in French class. That could be an option too, to say.
We would encourage you to do so.
Encourage
And
it.
it's, then they have no excuse for not following.
Absolutely.
Yeah,
And, you know,
it's called money.
Exactly.
Wow.
But
Oh, there's that.
there's that. But you don't be modest too. If you're teaching a course, you got 10 feature films that are the subject of the course, through the semester. It's perfectly reasonable, as I see it, to tell the students one of the costs of taking this course is you got to have a Netflix subscription. That's cheaper than any book you're probably going to buy for this semester. And on top of that, you're going to get a million extra movies to enjoy when you get a little time.
And they can watch it together. as part of it.
Yeah. All right, let's go to our next subject. Because we're going to have fun with this one too. Author's rights, publication agreements. Okay, ready? Yeah. All right. Now, just a reminder, what are the rights of a copyright owner? We've said most of this over and over again, but just a reminder, if I'm the copyright owner, so now our scenario here typically is faculty member writes something for publication. A journal article, a book, or anything else for publication. And let's assume I am the copyright owner, whoever I am. I am the copyright owner. As a copyright owner, I have these rights. And the top portion of the slide is the most typical, important part. I have rights of reproduction of the work and distribution of the work in copies. That's what publishing is. It's making copies of your work and putting them in the mail, figuratively or literally, and sending them out to people. Distribution. That's what publication is. So now I have these rights. And what the law is saying to me, I have the privilege of exercising those rights and sharing to find the publisher. I also like to think of ownership. This slide is what's in the statutes, but this slide is a lot about what's practical under the law. That as an owner, I've got choices, call them rights, to exercise those rights or to not exercise them. I've got the right to lock my manuscript up in the drawer and not let anybody see it. Now that's not in the statute, but that's an exercise of being the privilege of being the owner. The choice to disclose or not disclose. The right to decide when and how and whether it's ready to share or publish. The choice to grant permissions to people or deny them when they contact me. That's my choice as a copyright owner. And then some of these other things about Creative Commons and open access, that's my choice. And when we adopt at our universities an open access resolution about our faculty scholarly works, what we're doing is we're making that choice up front. I choose by voting for this policy and not opting out of it, as many policies allow, to grant that open access of my works up front. I'm making that decision today for my future works. So I plucked one copyright publication agreement out of the stack and looked at some of the relevant language. So here's some nice language. Ownership of the copyright remains with the authors. Oh, that's nice. The flip side of that language is you as the author hereby transfer your copyright to us as a publisher. That's the counterpart. Very common. It's very 19th century. It's still very much with us today. So we want to be, watch for this language. Read these documents carefully. They are changeable. Many publishers have a secret Plan B document that they do not show you until you raise questions. You go, okay, yeah, I know what you're talking about. They pull it out of the drawer and hand you the alternative. Yes.
Yeah, I'm editor-in-chief of a journal with
Good.
Elsevier. And
Our friends at
and your
Elsevier.
friends at Elsevier,
Our
right?
friends
So
at
the
Elsevier.
alternative to an author that requests that is, that's fine.
Yeah.
For $2,500,
Oh, yeah.
you get an open access
You okay with that?
copyright. I mean, that is really the alternative with a lot of, I do a lot of
Yeah.
publishing.
Yeah.
That is the alternative that people give to you in
Yeah.
today's world. You either sign the copyright release or you buy the open access.
With all respect, there are many publishers that allow open access at no fee at all. None.
In
None.
fact,
Yeah.
just an exception for the author exception policy. You just have to submit an addendum.
Yeah.
And all the ones I've worked with have allowed us
Yeah.
to.
Yeah, yeah, there are a lot of them. There are a lot of them.
Also,
It's really, it's a very strong, clear movement. I had a major publisher that's in it for the money hire me recently to redo all of their agreements. They wanted to make sure that they licensed back and didn't take the copyright and made clear back to their authors. They wanted to move into this new realm because they're confident they'll be able to sell copies and make money anyway. Despite that. So there's a real abrupt transformation going on in the world of publishing. And publishers are discovering that the issues are more complex. They're also discovering that their readers, their buyers, and their authors are a lot more sophisticated in the marketplace than they ever were before. And the opportunities to do more with these works exist today. It didn't matter decades ago if I gave away my copyright to any publisher because there was not much I could do with it anyway. Guess I had to practically chisel it on, in paper and pencil to make a copy. But today there's so much more I can do. And so the world is loosening up a whole lot.
What the other thing I'm seeing is if they allow you to keep copyright, they put an embargo on it.
Uh-huh.
So you've
Yeah,
got
let's talk
12,
about that.
you've got 12 months before you can kind of open it up.
Okay, let me show you some more. This is,
Yeah.
I'm gonna flip through a couple slides here. And this is from the same agreement, okay? Has this language. You, the author, you remain the copyright owner. And then it has this. In consideration of publisher agreeing to publish your article, the authors grant to the publisher an exclusive license to. Keyword, exclusive, exclusive.
Yeah.
So now what's going on is, this publisher has sat down with the copyright lawyer and said, our authors are wanting to hold the copyright, okay, but we want in return an exclusive license to publish, reproduce, transmit, distribute, display. Remember that list of the rights of copyright owners? All pretty much the same. It's pretty much the same in all forms and formats, whether or not. So in reality, between these two clauses, the publisher could have said, give me the copyright.
Right.
It's the same net result. Keep reading. Okay?
And switch.
Keep reading, though. Keep reading. So far, looked really good. Whoops, they just got it all back. Okay, it just flipped on us. So my name is on the title, copyright by me, but it doesn't mean very much in light of this language. Keep reading. Okay, but, so now we put the copyright here, and then we move all the rights over here, and now we're going to move some of the rights back over to the author. The author retains the following non-exclusive rights, which means the publisher could give these rights to somebody else too. That's what non-exclusive means. The right to use all or part of the contribution in any book, thesis, etc. So if you're writing a book, you can build it on this. This is good. This is good. To reuse figures or tables in an author's future work. This is good. I like this. Make photocopies. Didn't say scans, didn't say digital, it said photocopies. So they've got a format issue here. By the author, for use by the author in any academic institution where they work. E-reserves, it says photocopies. So now you can't even do e-reserves of your own piece, unless it's fair use, I suppose. to post a copy as accepted for publication after peer review. This is good. A lot of publishers latch on to peer review changes on the author's personal website or repository after a 12-month embargo before going forward. So we got a delay. It's good in that it's the accepted version after peer review, which is really important. I think having multiple versions out there is a lousy idea. We want one version findable. That's it. But there is a 12-month delay, funding by designated as soon as possible, but no later than 12 months after publication. Did that come out right? Yeah. No sooner than 12 months. Maybe it should have said. Yeah.
Except you left out what sentence in there that they put, that as long as it's not the publisher PDF version.
Yeah, and I think they should be encouraging the publisher PDF version.
Yeah, I mean, you can't do anything with that.
Yeah, yeah. Well, actually, I think what the publisher wants is for the researcher to find this version and then go to the publisher's site for the final.
But as they move them
marketing
into a system where they have to log into a system to do any changes,
You do.
you don't get
Yes.
that manuscript back.
Oh, I see what you mean. Or you'd have to recreate it manually. Yeah.
Your driver is out there and he says traffic's getting heavy. So I
Okay.
think
Was that thunder I was hearing too?
I don't know, but he says traffic's getting heavy. So
We're having too much fun. Okay, so here's some things to watch for. Notice it just said watch for it. I didn't say, you're going to get electrocuted, nothing like that. Okay, but you will. Okay, copyright transfers. When you sign your agreement, really watch for those. And then a third bullet point up there, make sure that the rights reserved back to you are what you reasonably, realistically need. If you think of others, get them. Watch out for the work made for hire language. Really watch out for it. The place in publishing world where it comes up most often is in connection with an article or more, you might more typically call it a book chapter that you're contributing to a new volume, a new book. It's going to be a set of edited works. Under the copyright statutes, that has a special place where it's allowed to be work for hire, but only if you agree in assigned writing. So watch out for that. There's really no particular need to have that as work for hire. It has a lot of other implications, and it's really okay to run that back to just even a copyright transfer would be better than a work for hire. And a license with clear rights back to you would be better yet. Elsevier is a very friendly publisher. It is. So, but be sure to select friendly publishers. No, I tease you because we all do. But I'll be quick to say that of all the big publishers that have been in this as a marketplace-driven publisher, I give a lot of credit to Elsevier. To hear me give a lot of credit to Disney this morning, I just don't.
What's going on?
I just don't. I think they're all just kind of doing their job. But Elsevier has actually is trying to move itself from that class of certain other publishers by really allowing, in most of your agreements, you do explicitly license back to authors a handful of rights, and have moved away, I think, from the interlibrary loan issues that have been haunting the system for many years. So we thank you for that. Keep up the good work. For those of you who have any connection with publishers, serving on editorial boards and so on, get involved. For those of you who are authors, read carefully. Read those agreements. Understand what you're signing. Do not hesitate to negotiate. Do not hesitate to ask for changes. The worst that will happen is the publisher will say, no, we don't do that. I'm sorry. They won't yank the project from you. I have never seen that happen. You could scare me if you've seen it. But they won't do it. They'll just say, sorry, we don't do that. But more often than not, I've had publishers agree. They say, okay, fine. I mean, seriously, I've had several publishers say, we have this secret Plan B agreement that we don't show anybody unless you ask. So you've got to ask. And then the last thing I'm going to say is this phrase, keep copies. Whatever you do, whatever you sign, even if you don't read it, even if you don't like what it's signed, even if you don't like anything I'm telling you, just do this. Keep copies of everything you sign. Click through signing, manual signature, whatever it is, keep copies. Because questions come up, just like they did today. I created this years ago, and now I want to include it in my teaching. I created this and published it years ago. Now I've got this invitation to include it in a book that's compiling chapters on this subject. And the questions come to me as in the form of, can I do that? And my answer begins, well, depends what you sign. Let's take a look at your agreement. And the most common reaction from authors that I get to my saying that is, what agreement? Or, I don't remember signing anything. Or, I signed it and I put it in the mail. You know, it's gone. Keep copies. Keep copies. This will put it together from this morning. One of the early points of this morning. How long do copyrights last? Pop quiz, not forever.
Life plus 70.
The life of the author plus 70 more years. When I say keep copies, how long do you need to keep those copies? For the rest of your life, plus 70 more years.
I'm taking them with me.
You need to keep them that long. And I'm really serious about that because I've had many instances where I'm working with a project, somebody, a noted author, a very important article, a piece written and published in the 1930s. I need to know what that author signed. That author's been long dead. I need the files. I need the files. Where are they? And you can imagine in most cases they don't exist. I'll break it to you gently. I've had many publishers come around threatening something, and I'll say, show me the article. I mean, show me the contract. What did the author sign? Do you know who's got what? And they'll say, oh, we moved offices 10 years ago. We threw away all of our files. Sorry, you got nothing. You got nothing. So, I say this to you as authors. I say it to publishers. I say it to all of us. Keep copies. Keep copies. So on that happy note, any last questions? Any last questions?
How about ResearchGate? What's your thoughts about
Well,
repositories and ResearchGate?
I think of ResearchGate as another repository, just voluntary.
Okay.
And so whether or not somebody can contribute their article to ResearchGate, if that question came to me, I'd say, well, let's take a look at what you signed. You know, maybe the example license the example agreement I put here said you can put it in your own repository, but the next agreement might say and in any other repository. I don't know. Depends how it's worded. So I want to see I want to see what you signed. Good.
What do you see coming in the future? Because I've read things about how people on the copyright side want to actually extend it to eternity minus a day.
Yeah, I don't think that's
For
going to happen.
example, that the Supreme Court has been muttering about weighing in on this. And then especially with the rise of this 3D printing.
3D printing is a fascinating bundle of issues
You know,
there.
as in, I see a dress, I love it, I want to copy it, or I have a part I need to copy.
Fascinating bundle of issues there about 3D printing. We'll save that for another day. But I will wrap up with some thoughts about the future. Number one, this is a political animal, and whatever you hear about changes in the law, you know, the mood in Washington is to not get a whole lot done these days, and we could say that in general. So I don't expect major changes. I know that, you know, Disney was supportive of the last extension of copyright, and people are wondering, well, when we get to the year 2023 or whatever it is, when Steamboat Willie enters the public domain, you know, will they be back asking for more? I expect not. I expect not. And for all kinds of, it's a long list of reasons why not. And among those reasons are here I am bailing on Disney again. It really wasn't Disney that passed that law. It was Europe. We went to Life Plus 70 because Europe went to Life Plus 70, and the rest of the world ain't going anywhere in these issues. So I don't see the push there at all. And the second thing is you cannot in this environment open up a piece of copyright without the whole thing exploding on you. So I don't think Congress wants to go there. The Copyright Act of 1976 that Gerald Ford signed into law in 1976, got a little bit about that this morning. The process, remember, this is in the era of pencil and paper and mimeograph machines. The process of beginning the studies in Congress and then the hearings and bills that led to the 1976 Copyright Act, in that era of technology, the process began in 1955. It took 21 years to get something that Congress is ready to vote on. How long will it take this time? Forever. Forever minus a day. So thank you all very much. It's been a
You guys run to every,
Oh,
I
we'll
want
be
to
fine.
thank
We'll be
everybody for
fine.
joining us. The library hopes to have many more workshops like this on author rights specifically and other things and copyright. Please go ahead and do an evaluation. We have it online. If you RSVP, you will also get the archive sent to you. I'll have your email. But the landing page will have Kenny's slides on there. We'll have the archive on there and also a link to the evaluation as well for everybody. So thank you again. It was a wonderful session. We appreciate your
Thank you.
participation. Thank you so much.